Sheikh Muneer Abduroaf, inshallah, will be discussing with us, dear listeners, this morning the impact of the South African law on the Islamic Interstate Succession Act. Just a brief biography about Sheikh Muneer Abduroaf. Sheikh Muneer Abduroaf is a senior lecturer at the University of the Western Cape Faculty of Law. His formal qualifications include a doctoral degree in constitutional theory, a master's degree in transnational criminal justice and crime prevention, a bachelor's degree in South African law, as well as a bachelor's degree in Sharia law. Sheikh Abduroaf has been admitted as an attorney of the High Court of South Africa in 2012. He endeavors to use his knowledge and skills acquired during his studies to alleviate hardships faced by communities in South Africa. Sheikh Abduroaf also uses his knowledge and skills acquired during his studies to assist community and religious organizations with aspects concerning the law. He is a senior advisor to the Muslim Judicial Council, the MJC, where he advises in matters of a legal nature. Sheikh Abduroaf also volunteers as a member of the Constitutional Committee as well as the Mediation and Arbitration Committee, including trying to mediate disputes within the Muslim committee concerning mosque affairs as well as marital issues. Sheikh Abduroaf has been appointed as a CRL Rights Commission by the President on South Africa during 2018. He serves as a commissioner in the Legal Services and Conflict Resolution Unit within the Commission. The unit aims to alleviate hardships faced by CRL communities in South Africa. Sheikh Muneer Abduroaf, ahlan wa sahlan wa marhaban bikum, and welcome to this morning.
Wa alaikum salam, Sheikh Qari Nadeem, and shukran for having me here this morning.
Absolute honor for us, Sheikh Muneer. Dear listeners, as we've said in the beginning, Sheikh Muneer is going to basically take us through the impact of the South African law on the Islamic law of succession. Sheikh Muneer has also, having a doctorate in law, compiled a doctoral thesis that specifically deals with this topic in this regard. Sheikh Muneer, will hand over to you, inshallah, for you to take us through. There are a number of aspects or elements that we'll get into, but if you could maybe take us through and give us a surface overview of the impact that the South African law, we know of the new legislation that has been enacted, and if you could maybe take us through the present status quo, where are we right now in terms of South African law, the impact on the Islamic law, and of course the importance of also having a will in place, a valid will in place.
Shukran Qari Nadeem for that introduction. Yes, the thesis or the book currently is the title, The Impact of South African Law on the Islamic Law of Succession. It is basically a thesis that has been accepted for publication by the University of the Western Cape Faculty of Law after having gone through the peer review process of examination and thereafter approved by the Senate High Degrees. So now that thesis has been published. It is available on the website of the university, and a copy will be made available here at the Academia Library as well as a link. The subject matter basically looks at the broad question of the application of Islamic law within Muslim minority countries, like South Africa. Yes. So we're not part of the majority of the country, 30-40%, we just under plus minus a few percentage of this country. Now when we apply our laws as we are required to, as in terms of Sharia, the Quran and the Sunnah, we might find some challenges, as is found by many other communities, minority communities around the world. My thesis was looking at a specific part of the application. It was to look at the laws of succession, also referred to as the laws of inheritance.
Yes.
And we're looking at the impact of South African law, of how the South African Constitution, right, which allows for the right to freedom of religion, which allows for the right to dignity, equality, and all of these rights, as beautifully stated in the Constitution, how this has impacted upon applying Islamic law, more specifically the laws of succession. So this thesis has looked at a number of different avenues. It looked at what the Islamic law of succession in South Africa is all about. It states there that the majority or the dominant schools of law followed in South Africa is Shafi'i and Hanafi. And we've looked at what the rules are in this regard. It also looked at the South African law of succession and how the South African law of succession has to date accommodated the application of the Islamic law of succession. Another chapter in the thesis looks at the practical application of the Islamic law of succession within this African context, where a person drafts their will and the various pitfalls that could occur as far as estate planning is concerned, and a scenario where there is disqualifications, a person has more than one wife, it might be a child was conceived out of wedlock, it might be a child has been via artificial insemination, and what are the consequences in the South African law and the Islamic law? Then we have another chapter in the thesis that compares the application of the Islamic law of succession as applied in South Africa to another country which is similar to Africa, which also has a constitution, more specifically Singapore, and see how it is applied over there in comparison to how it is applied in South Africa. The last chapter in the thesis looks at the constitutionality of the Islamic law of succession within the South African context, and the big question of the 2:1, where the son inherits double the share of the daughter.
Yes.
If that is challenged, what would the outcome be? And that is basically how the thesis ends off.
Fantastic. I think quite comprehensive in terms of the subject matter or the concerns that the average Muslim, one that would qualify to, of course, have an estate, ought to consider. For the listeners, why is the subject matter important? Why would a Muslim living in South Africa meeting the threshold for their estate value, as we know, there is a threshold of about 250,000 rands where one would need to have their estate reported to the master's office. And of course, this would find application where a person does have a valid estate and he has something to bequeath. But why is the subject matter important for us, a Muslim living in South Africa with a valid estate?
Shukran for that question, Qari Nadeem, and a very important question I might add. Any person who passes away in South Africa, as very importantly stated, if the value of the estate is more than 250,000 rand, we have letters of executive issued by the master. If it is less than 250,000 rand, then in that instance you find that letters of authority, or you'll be a master's representative. So there's a different process for both instances. But in both instances, you'll find that the matter should be reported to the master. And if there is a will, the will should be a valid will. That's very important, because it might be that I write on a piece of paper that I would want my estate to devolve in a certain way. But if it was not executed properly in terms of South African law, it will be deemed as if that will would not be accepted by the master unless it is an application is made to the High Court to have the will condoned. And if it is condoned, it would be okay. If it's not condoned, it would be deemed as if you died intestate, which means that the South African law of intestate succession will find application, which is very different to Sharia law. And in this instance, it might become quite problematic. And to answer your question, knowing these various nuances, it therefore becomes important for each and every South African Muslim to know what the law is concerning the laws of succession and what is required in terms of Al-Quran, chapter 4, Surah An-Nisa, verses number 11, 12, and 176, which expounds as to how the estate of a deceased Muslim should be administered and devolved in terms of Islamic law. And therefore, I think this thesis is important to have a look at. It's available online, and it would be at the library as well, to look at what Islamic law says, what South African law says, what requirements must be met in order for a will to be valid. Many times you find a person, a father says, look here, right, I'm drafting my will, I'm a bit ill. My son, just sign here as a witness. You know what I want to happen. That is problematic within the South African context because that will has not been executed properly. A son is a beneficiary and he can't be a witness to a will.
Very, very important point. If, Sheikh, if you could please maybe just touch on who are those that are allowed to sign on a will that will render it valid, and who is it that is not allowed to sign on a will that will render it invalid, as you've just touched on in terms of the beneficiaries?
It's very important, Qari Nadeem. We find that many a time a person executes a will or drafts a will and has it signed. The witnesses, this is the main part of the execution process, must not be a person who is a beneficiary. Right? Now, who's a beneficiary? It would be, in terms of Sharia, your sons are beneficiaries, your daughters are beneficiaries, your parents are beneficiaries, your surviving spouse is a beneficiary. Even the person that you appoint as the executor or nominate as the executor of the will, that is a beneficiary who cannot be a witness. As well as the spouses of the beneficiary, right, should not witness the will. Right? If any of these persons who are deemed to be beneficiaries of the will, or the spouses, if they sign as witnesses, then it becomes a problem. The will is still valid, but it will basically be an instance where the persons would be disqualified from inheriting. Right? So it's important to note that as far as the wills are concerned.
Sheikh, if an executor is appointed of a particular estate, so he's appointed as an executor, but he's not a direct beneficiary in terms of the proceeds of that estate, will that still constitute a valid will?
Yeah, the will still be valid. The problem would be whether or not he can benefit from the will.
Okay,
right?
But if he's not, so it's not a family member, it's not one of the children, it's not one of the spouses, not one of the family members. This may be a friend, somebody that is trusted to act as an executor for the estate, but he doesn't inherit anything of the estate.
Yeah, in that
possibly work?
Yeah, that could work, but he would be the executor, but not a witness.
Not
so
a witness.
That is what we were stating. So as soon as you become the executor, or you are a beneficiary, or you are giving the person a bequest of your wasiyah, then in that instance, that person or those persons, those individuals, as well as their spouses, should not be a witness. The best case scenario is where you just get two persons who are not related to the family at all, and they witness you signing the will, then it should be okay.
100%. Barakallahu fiqh for taking those questions. With regard to the thesis, has there been any journal article publications that have come out of the thesis?
Yes, alhamdulillah, the subject matter, I found it to be quite interesting, and even the local or the local community in South Africa, as far as academia is concerned, as well as the international community, is quite interested in knowing the affairs of South African Muslims and how we apply our Islamic laws, also in this instance Muslim personal law in South Africa. So alhamdulillah, while I was busy with the thesis, one of my chapters has been published in a book, International Survey of Family Law. We have looked at the Islamic Law of Succession as applied in South Africa. After the thesis has been approved by the Senate High Degrees and I received my doctorate, I've also taken parts of the thesis, the various chapters, and made the various changes to make it into articles. And each and every chapter of the thesis has been published in both local and international journals, which shows how relevant the subject matter is.
Indeed, definitely.
Alhamdulillah. Some of the chapters have even been made into 2 articles. The only chapter that has not been published was chapter 1, which was the introduction to the thesis.
Sure.
But alhamdulillah, those are also available online as well.
Excellent. In terms of the different countries that you've said, that have, the journals have made themselves, or they've basically reached other countries as well. Could you perhaps...
Yeah, the journals, alhamdulillah, there are a number of them. There's the Electronic Journal for Islamic and Middle Eastern Studies, EJIML, that is in Zurich in Switzerland. There is a journal in, there is the Manchester Journal of International Islamic Studies, that is in the UK. And there's also the Journal Sharia, which is based in Indonesia, right? And there's some others as well. And there's many. The local journals would be Obata Law Journal. There is a Journal of Comparative Law in South Africa. There is also the De Jure Journal based at Nelson Mandela University. So alhamdulillah, there's approximately 7 or 8 journals that were interested in the subject matter which came out of the thesis.
MashaAllah, we ask Allah to accept you and to continue to use you and to use you far around, all around the globe, inshallah, for the khidmah of His deen. This is now quite a loaded question, Sheikh Muneer, and it would be interesting to get your take and your feedback on it. In your opinion, do you think that the South African government will enact legislation to give effect to the Islamic law of compulsory succession, given obviously the outward disparities that exist in terms of the different distribution portions to males and females, etc.?
Yeah, that is actually
the problems that could arise, or that we already witness, rather.
Yeah, shukran for that question. And this is a very interesting question, and a question that is asked by many regarding the differentiation between certain males and females within the Islamic law of inheritance or the Islamic law of succession. As a starting point, it should be noted that it's not under all circumstances that males and females inherit different shares. If you look at the situation where a person passes away leaving behind, let's say, a son and a mother and a father, but the mother is female and the father is male, both of them inherit equal shares. In terms of ayah number 11 of Surah An-Nisa, وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا السُّدُسُ مِمَّا تَرَكَ إِنْ كَانَ لَهُ وَلَدٌ. So there's equal shares. If you look at the ayah number 12, and we're looking at a specific type of beneficiary, which is a uterine sibling, a brother or sister who inherits that has the same same mother but different father, a uterine sibling. Those brothers and sisters, they inherit equal shares as well. But there is an instance, in terms of ayah number 11, where it refers to يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ, where they're looking at the inheritance of, let's say, for example, children or descendants, where the son inherits double share of the daughter. Now the question posed is, will that be problematic within the South African context? Now if you look at the South African Constitution, we find that under Section 9 it looks at equality. Right? So all laws governed by South Africa must basically must not discriminate unfairly, right, based on whatever sex, gender and all of those things. So it might be a problem for the South African government to enact legislation, a law by Parliament that gives effect to a piece of legislation that differentiates between a male and a female, even as far as inheritance is concerned. However, right, it can't be said with absolute certainty that it will not pass constitutional muster. But on the other hand, what we do have is the right to freedom of testation in terms of the common law. So I can draft a will, also referred to as an Islamic will, stating therein that I leave my estate in terms of the Islamic law of succession. Right? Or I could state in my will, without referring to the Islamic law of succession, I could then state that I leave to my son so much and to my daughter so much, based on the right to freedom of testation. And in that instance, if it is challenged, right, we have to deal with it at that point in time. But it would be highly unlikely that a case would be made that if I'm not doing it because of discrimination, I'm doing it because I want to give my son so much and my daughter so much, it shouldn't be a problem. But if, however, I state that the reason behind it is because the one is male and female, and that is challenged in a court, a high court or Supreme Court of Appeal or Constitutional Court, that might
from
be
a gender equality point of view.
From a gender and sex point of view, and the constitution that requires that the government cannot discriminate unfairly based on any one of those grounds, as well as any individual. There has been some case law in this regard about a year or two back in the Jaga, which went up to the Constitutional Court, where a person, he had a big farm and he left something, part of the farm to his children, males and females, and thereafter to their children. But thereafter he wanted to keep it within the family name. And he said, thereafter it goes only to the descendants of the males. Right? So that was a problem, and they challenged that on constitutional grounds, and it was found to be unconstitutional, and the court basically gave a ruling in that regard. So the ultimate final outcome as to a challenge to Islamic law, I cannot say with certainty, but the possibility is always there. Within my thesis, however, in 2018, prior to the judgment, I came to the conclusion that based on the right to human dignity, based on the right to property, as I can give to whoever I want while I'm alive, what I would want to give, why can I not do that once I pass away? At that point in time, the outcome of the thesis in 2018 at least was that it would pass constitutional muster. The current state of affairs might be a bit different.
Sure. Thank you very much for that, Sheikh Muneer. Sheikh Muneer, obviously given everything that you have mentioned, or what we have said, rests upon a person leaving behind a valid will in place. And you've also drawn the listeners' attention to the fact that if a will is not executed correctly, then it could mean that the estate would be, how would one say it? It would be regarded as an estate interstate.
Interstate, yeah.
Yeah, and if you could maybe take us through and explain that point a little bit more, and the implications of that in terms of the assets that would be left behind. Would it mean that the entire estate would be subject to certain laws of the country in terms of the distribution, or would the beneficiaries receive the full estate? What are the possible repercussions of that?
Yeah, in the thesis as well, in the application of the Islamic law to the African context, there's a specific chapter which looks at the scenario. And if you look at that thesis, you can find it there. But to answer the question as well, previously we've spoken about the signing of the wills, right? And where a person would be disqualified if you're either beneficiary or the spouse to a beneficiary, right? The will remains valid, but disqualified, you can't receive the benefit. However, if you would also inherit in terms of the laws of intestate succession, then you might receive that benefit, whatever is a lesser. Right? So there is a certain rule that finds application there. But let's say the will was signed only by the executor, only by the testator, the person whose will it is, but there was no witnesses. Sure. Right? Then it becomes a problem because the will was not executed properly. It's only if that will is condoned by the Master of the High Court after an expensive process that the will be accepted and basically administered accordingly. If the will has not been accepted or condoned by the Master of the High Court in terms of the respective section of the Act, then in that instance you would die intestate. Now when a person dies intestate, it basically means, and many people think it goes to the state. No, it just means that it will be distributed in terms of the laws of intestate succession. And there's an act that was brought into effect in 1981, the Intestate Succession Act 81 of 1987, and it directs as to how the estate of a person must be distributed in the event where he passes or she passes away without a will. Right? As Muslims, we find in the Quran, it refers to ayah number 11, 12, and 176. If you have no will, the law is. But in this African context, if you pass away without a will, it doesn't automatically mean the Quran and Sunnah finds application. Sure. It means that the Intestate Succession Act 81 of 1987 finds application. And this is discussed in detail in the thesis. By way of example, Let's say a person passes away with a mother, a father, a son and a daughter and a wife. All right. In terms of Sharia and those verses quoted early on, the mother should inherit a sixth, the father should inherit a sixth, the wife should inherit an eighth, and the residue should be distributed between the son and the daughter in the proportion of 2:1. The 2:1 comes again in.
This is as far as the Quranic injunction
As the Quranic injunction is concerned. Let's say the estate is worth R1 million. Now, in terms of that estate, we know what the Quran says. If the person passed away with a will, but was not signed properly, it was not condoned by the master, it's intestate. Or if the person passed away without a will, it's intestate. We mustn't always think that, look here, my children will do things properly. Sometimes, if the South African law gives them more, they might take that.
Yes.
In this instance, the African law will say, what is more favorable for the surviving spouse? If it is that we take the R1 million divided by 3, which is basically the surviving spouse and the 2 children, a child's portion would be plus minus 333,000 rand, 1/3 of the million. That amount is obviously more than 250,000 rand, as we have spoken about earlier on, the criteria. Right? The surviving spouse now inherits the third of the million,
Sure.
and the remaining 2/3 is shared between the son and the daughter equally. Right? Son gets 1/3 and daughter gets 1/3 of the million. Right? That's quite different to what Islamic law has stated. And also what we've seen now is that the parents inherit nothing. So where the Quran says 1/6 to each parent, 1/8 to the surviving spouse, and 2:1 to the son and the daughter, South African law just looks at the surviving spouse, the 2 children, and they sharing the estate equally. And it's in that vein that it's so important for us to understand what the implications of the Islamic law is on our estates, and then to plan accordingly, either by giving away gifts while we are alive, if you would want someone to have something, or understanding and acknowledging and knowing and doing the right thing. When I pass away, Sharia law should find application.
Sheikh, thank you very much for that. I think that's a very, very important point. When we find this often among families, where because of the injunction of the daughter receiving, or the son receiving double the share, twice the share of the daughter, we find that often many parents give preference, even during their lifetime, to what they give to their sons over what they give to their daughters. The fact that the Quran exhorts us to give the son double the share of the daughter, could you perhaps take us through the reasoning behind this from the perspective of the Sharia, and whether it means that in your life, there ought to be a preference given to the sons over the daughters? And this question came particularly from the female listeners out there. But it's the case, but it's rife within the communities and within certain sectors of society. This is what we witness.
Yeah, shukran for that question, Qari Nadeem, and to whoever posed the question. If you're looking at the laws of inheritance, right, these are the laws that apply once you pass away. Right? Once you pass away, Allah says in the Quran, لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ. There are instances where the males and the females inherit equal shares. There are even instances, if you read the thesis that's available online, where females inherit more than males. Right? Females in an estate inherit more than males. So there are males available in the estate, but because the females have a stronger connection to the estate. Let's say there is a full sister and there's a consanguine brother. The full sister will inherit, in this instance, everything, and the consanguine brother, even though he's male, inherits nothing. Right? This is now al-asaba ma'al ghayr example. But to answer the question, there is a rationale behind it. And the rationale is, if we look at the Sharia as broad laws, the responsibilities placed on males are more than the responsibilities placed on females. Right? So while you are alive, you should actually give your sons and daughters equal shares, because the Prophet ﷺ says, when he saw the one Sahabi giving preference to one child over the other, and said, do you give this to all your children? And the Prophet said, I will not be a witness to something like this. So we have to be fair with all our children while we are alive. But once we pass away, Allah has stated that this is how your estate should be distributed. And the question of 2:1 becomes an issue. But let's say, for example, both the son and the daughter were to get married, right, the responsibilities placed on that son is more than responsibilities placed on the daughter. Right? If he gets married, he has to pay a mahar or maskavi, right? And his prospective wife could ask for R1,000,000, maskavi, a house, a hajj, whatever she wants, which might be more than the money that he inherited.
Sure.
That daughter in the example we have given, right? If she gets married, she can ask for R1,000,000.
Yes.
Right? During the marriage, the responsibility of nafaqah, of maintenance, is upon the male and not the female. Right? So that son who gets married must now maintain his wife. She doesn't have to use any of the money if she wants to. Alhamdulillah. If she doesn't want to, she can loan the money to him and claim it back later on when he does have a better job. Right? But this is what the laws of Sharia says. The daughter, on the other hand, she has a right to nafaqah, and also when she has children, it is her husband who has to pay for these financial expenses and so forth. So it wouldn't make sense really if Allah subhanahu wa ta'ala were to say, look, these responsibilities fall on the male, and at the same time give them equal shares in that vein as well. And if the female, on the other hand, is not able to look after herself, there would also be a male that has to look after in terms of the laws of Sharia. Right? So this is the rationale or the wisdom behind finding this ruling. But there's no specific ruling in the Quran, in the Sunnah, which says this is the reason. This is only based on analysis of the various texts.
I think it from the qasas, or the story or the narration that you mentioned of the Prophet ﷺ, where he witnessed an injustice by the father to the daughter or the daughters, and the fact that he said that he does not want to be witness to this is proof enough to show that the Rasul ﷺ encouraged fairness throughout the life of a parent, to be fair in the same way that one would have to be fair if you've got more than one wife, and fairness is encouraged to them. In the same way, you have to be fair to your children as well during your life.
Yes, definitely. If you're looking at while you are alive, that would find application. You have to be fair between them. And when you pass away, obviously we don't want the males then to say Allah is unfair by giving all these responsibilities on us, and we get exactly the same as our counterparts.
Indeed, as you've beautifully mentioned, the wisdom of Allah subhanahu wa ta'ala, and it comes down to a question of rights. Obviously the greater right being on the husband, on the male, to provide for the female, as Allah tabarak wa ta'ala also says, "Ar-rijalu qawwamuna 'ala an-nisa." They are the ones that bear the ultimate responsibility in terms of seeing to the needs. Sheikh, on the particular point of wasiyah, if you could basically take us through in terms of what one is allowed to bequeath to those that are not ordinary beneficiaries or ordinary heirs, and if one would like to make an external contribution, how is that governed within the Sharia in terms of a percentage, and what amount would one be allowed to dispense with?
Yeah, shukran for that question, Qari Nadeem. And if you read the thesis as well, you'll find under one of those chapters, we now look at the practical application of the Islamic law of succession within the South African context. I mentioned a number of issues that could come about. One of it is, let's say the child is conceived out of wedlock. Right? So out of wedlock, they married before, or basically the child was conceived before they got married. And the issue of when the child is ultimately born. The issue of where you are married and your wife basically sleeps around with another man and there's a child. What are the implications over there? Is a wasiyah required or not? It could be that you adopt a child and that child is with you. Is adoption allowed in Islam? And that is also discussed in the thesis. And also, if that child is now with you, what can you give that child? If the child is of a different religion, like there might be non-Muslims out there, they become Muslim or they revert back to Islam, but the children remain Christian because la ikraha fi din, you can't force anyone to become Muslim. But nonetheless, you'd want to give something to them, right? Under all of these instances, right, you can make use of the wasiyah in order to benefit your children, your adopted children, be it a child conceived out of wedlock, be it a child out of another religion, all right? Be it your wife of another religion, because it might be you marry a person of Ahlul Kitab, a Christian or a Jewish lady, right? She's disqualified because she's of a different religion, but you can make a wasiyah in her favor. So the mechanism of the wasiyah is there, and as discussed in the thesis in more detail, you can make use of it in order to give effect to your wishes even after you have passed on.
MashaAllah. In terms of the percentage of the wasiyah, is there a regulated amount?
Yeah. Yes, Sheikh Qari Nadeem, it would basically be the 1/3. And very important to note as well, it is what we refer to as 1/3 of the net estate. Right? So once a person passes away, there's something referred to as the gross estate. It's discussed in the thesis as well as to the breaking down of the estate. The person passes away with R1 million. If he has debt to the amount of R1 million, there's no net estate, there's no wasiyah, and there's no inheritance. However, let's say there's R100,000 debt and janaza expenses and all of that. We're sitting with a net estate of 900,000 rand. From the 900,000 rand, you can make a bequest, a wasiyah, in favor of any person who does not automatically inherit as a compulsory beneficiary, right? Like your son, daughter, parents, and surviving spouse, for example, that they could inherit up to a maximum of 1/3 of that 900,000 rand, which in this example is a 300,000 rand. And it's important to note the difference between the gross and the net, because it might be that you make that wasiyah, and when you pass away, your estate decreases, and that wasiyah is more than the 1/3, then it does become problematic in terms of Islamic law.
Sure. How does the South African law actually recognize certain clauses that existed in a will where there was a wasiyah, or a person who was not an ordinary beneficiary but nominated to basically inherit from the wasiyah point of view?
Shukran for that, Qari Nadeem. But basically, if you're looking at South African law and the common law right to freedom of testation, you can do with your estate as you so wish.
So it is recognized.
Yeah, so you can basically make the wasiyah, and at the same time, normally what we put in the will is I give the 1/3, 1/6, anything less than 1/3 of the net estate to, let's say now, to Academia Library. And the rest of the estate, that is where we have this generic clause, stating that should be distributed in terms of the Islamic Law of Succession, and for purposes of giving effect to this, a Islamic distribution certificate issued by the Muslim Judicial Council, SA, for example, here in the Western Cape, will be binding upon my executor and the estate. So in that way, we are also ascertaining who the beneficiaries are. And at the same time, it's also important to note that when you're drafting your will, you might have one wife, and when you pass on, you might have three. When you're drafting the will, in executing the will, you might have one child. When you pass away, you might have none or more. Right? So the Sharia doesn't apply at the time of the executing of the will, but at the time of your death. And therefore, it's important to update the will if you are stating who the beneficiaries are, or alternatively, to refer to an Islamic distribution certificate.
MashaAllah, tabarakallah. Indeed, excellent feedback and enlightenment from yourself, Sheikh Muneer. Sheikh Muneer, in terms of just a question that comes to mind, where a person comes into the fold of Islam and he has got a valid estate to the value of approximately R1 million. He now has, so he becomes Muslim. He is still married to someone that is out of the fold of Islam. She is not from Ahlul Kitab as well, and none of his children are Muslim. What happens to his estate at the time of his death in terms of the Islamic law of distribution?
All right, so in the instance where a person now embraces Islam, it does become a big problem, especially if the spouse is not of Ahlul Kitab. The marriage would be quite problematic. But as far as inheritance is concerned, in that instance, because they're not of the same religion, all right, a beneficiary, the tie would either be marriage or blood. All right, so the marriage or blood would be the tie, and over and beyond that, there are certain disqualification. For example, not being of the same religion. All right, that would be the disqualification. But then in that instance, you can only make use of the wasiyah to benefit these individuals. So I can use the wasiyah to benefit my sons and daughters who are of a different religion. However, we've referred to the limitation of the 1/3, sure, right? And that becomes an issue now. What happens to the remaining 2/3?
Yes.
Because in this instance, we have 2/3 remaining and there are no beneficiaries. Generally, if anyone, even of the cousins, become Muslim, right, they can take that 2/3. Because technically, there is a hadith, the Prophet ﷺ, he says, أَلْحِقُوا الْفَرَائِضَ بِأَهْلِهَا فَمَا بَقِيَ فَلِأَوْلَى رَجُلٍ ذَكَرٍ. This is also explained in the thesis in some detail, I think in chapter 2. Right, where you assign the fractional shares to those shared beneficiaries, and whatever remains goes to the closest male relative. At times it would be the son, the father, it could be the brother, it could then be the nephew, the cousin, and the uncle, and so forth. And we go out. And if any one of those persons are not Muslim, they are disqualified, and we go on to the next one. But if, as in your instance, you are saying there's no one at all right, then in that instance, there's 2/3, and where does it go to? The ulama have spoken about this, and the majority say it goes to Baytul Mal. That is now basically public treasury.
So to a sadaqah.
Yeah, but then the question is, do we have Baytul Mal in a non-Muslim country, a Muslim minority country, and in this instance as well? And the ulama also speak about the question, is it possible to have a Baytul Mal in this point in time? And therefore, they refer to something referred to as Rad, doctrine of return, and all of that. But in this scenario, let's say there is no Baytul Mal. There is an opinion found in the Hanafi madhab that then does say that you become a universal legatee, right, where you are allowed to bequeath more than that 1/3. So because there's no compulsory beneficiary, a person who is entitled to it into the Quran or the Sunnah, then that limitation of that 1/3 is then removed, and you can then give everything to your non-Muslim relatives.
Barakallahu fi. Thank you for taking that question, Sheikh Muneer. Sheikh Muneer, your thesis, you've spoken extensively about subhanallah, and I think definitely a valuable tool, for the Muslim South African to basically consider, read up on, and acquaint himself with the laws pertaining to inheritance, and of course from a constitutional point of view, the onus that rests upon a person to ensure that he has a valid will in place, and of course the guidance that he would find within the theses to ensure that the clauses are sort of compliant and he does things correctly. Where can one obtain a copy of it? Is it perhaps available in digital format on a website? How could we access it?
Yeah, for that, I'll make a copy available here for the academia library as well. It is available in soft copy as well on the University of the Western Cape's website, where I'm in the Faculty of Law in the Department of Private Law. All you can just do is type in my name, Muneer Abduroaf, and succession law. Then you'll find all you'll find the theses over there, as well as under my portfolio, all of the journal articles that has been subsequently been published either from the thesis or outside of the thesis. Right, the rationale behind the Islamic distribution, whereas 2:1 is concerned, is in the thesis as well as in journal articles later published, and all aspects related to succession, specifically in the South African context, can be found there. Difficulties, for example, the Musa versus Hanike case, where there were two spouses, a polygynous marriage, where the Master of the High Court accepted the two marriages for purposes of the Islamic distribution certificate. The Registrar of Deeds, however, did not accept it, and where it became problematic. There are a number of articles that are relevant and impact upon our South African community that can be found on the website of the University of the Western Cape, as well as on the various journal platforms. You can just type in the name and
Sure.
surname, and you'll see it pop up, inshallah.
Excellent. So there you have it, dear listeners, fully available on the website of the University of the Western Cape, and I think you've got to put in Sheikh's name,
Yeah.
Muneer Abduroaf,
Yeah.
Succession Law.
Yeah.
Fantastic. We just want to thank you and take this opportunity for thanking you, Sheikh, for making yourself available today, and for the beloved listeners, definitely a very, very valuable and a very informative session. I think we have just a few minutes left. Any comments in closing from your side?
Yeah, shukran for that, Qari Nadeem. My final comments will be, after having gone through the laws of succession and its application in South Africa, and looking at how it applies in many places around the world, I basically have many people coming to me and asking me questions and having consultations with me concerning their affairs. And at many times I find that people are passing away either without a will, which means that the South African law finds application, and then the families are fighting. Or the person
Yes.
passes away with a will, but it's not Sharia compliant, and the families are still fighting. You also find that people have Islamic wills and the people are the family are
Still
fighting.
fighting.
Yeah, so the fighting is there. But at the end of the day, it becomes a problem where they are fighting, but they are getting the money for free, and you are also being held accountable because you are basically saying that you are not happy with what Allah subhanahu wa ta'ala says in the Quran. So my advice would be that do a bit of estate planning. If this is what you think should work for your estate, for your family, give the houses to all your children now while you are alive. Give it to them all, and it's theirs and it's done. And if you want to make use of the house, ask him if you can get the usufruct of the property. So when you pass away, then nothing needs to happen because they are the owners already. But whatever little you have left, or a lot that you have left, make sure that that is distributed in terms of Sharia law. Don't take the chance and say, no, I'll deal with it. I even heard someone say, no, I will deal with it when I'll speak to Allah about it. No, this is not, I think, how, it's a very, very dangerous statement.
Definitely.
Rather say, according to what Allah subhanahu wa ta'ala wants, and my family, they will sort it out. So that's my final comments.
Plan in advance.
Yes,
Most definitely. Barakallahu feek, Sheikh Muneer. May Allah increase you and bless you. And once again, thank you very much. Beautiful session. And inshallah, we look forward to having you again at some point in the future again. Yeah, Jazakallah
Shukran
khair.
for having me.
Assalamu alaikum.
Wa alaikum salam wa rahmatullahi wa barakatuh.
In pursuit of empowerment through knowledge for all, Academia Library Multimedia Studio.